Further hearing in the appeal, Mohamad Jiaved Ruhumatally and the State of Mauritius and another.
Mr. Director.
Thank you, my lady and my lord. Yesterday I indicated I would take about half an hour. Maybe I'm going to take less than that.
Yes.
First thing, the authority, the judgment that the board was asking, that is the ruling of the learned judge regarding the submission of no case to answer. We made copies available to my lady and my lord, as well as the case of largesse.
Yes.
Yeah. In the ruling given by the learned judge, he referred to some French extract. We do apologize, we have not provided with appropriate translation, but if need be, we would be grateful, we would assist if need be. Yesterday, my lady and my lord, before adjournment, I was addressing the board with regard to the issue of joint enterprise, and I think I've referred the board to all relevant cases, except one case which I'm not going to go through, but I would wish to mention, the case of the King and Surange, which is in supplemental bundle pages 110 to 120, which again confirm the principle about the participation of a quarter. A minimal participation would be enough, and a quarter would be considered as having been involved in the offense, even if he joined at a later stage. And agreement to participate together can be inferred where there is a kind of tacit agreement. So all these cases we mentioned, in fact, establish these principles. And basically, we will submit that the de minimis principle, strictly speaking, doesn't apply in a situation of joint enterprise.
Sorry, the de minimis?
The de minimis principle.
What do you mean? Sorry.
The de minimis principle was referred by the appellant, but was not really argued before the board.
Okay.
So I'm not going to insist on that, but just to mention it.
At the moment, Mr. Director, I'm not clear what is meant by that.
All right. The de minimis principle is relied on by the appellant in their written case. That is, it would mean that there must be a substantial contribution to the death. Something that is more than de minimis.
Yes.
But we say that in a situation of joint enterprise, the de minimis principle strictly is not applicable.
Yes, I see.
This is the point I would wish to make.
That's helpful. Thank you.
Thank you. Next issue I was asked to make submission was on the issue of premeditation, more precisely with regard to the observation made by the learned judge in his summing up, with regard to the directions given to the jury, where he said that the appellant seemed to have acted calmly. That is to be found at page 288
yes.
of the record.
Which act appears, seems to have acted calmly in removing the shirt and carrying out the act of tying the knot with the deceased.
Yes, at line 16, he said the following. As he finished that job, he approached the deceased and saw the state which the latter was. The accused then seems to have acted calmly in removing his shirt, carrying out the act of tying the mouth of the deceased, which act appears to have been uncalled for in the circumstances suggested earlier. In fact, my lady and my lord, the learned judge was explaining to the jury the requirement of the law when it comes to premeditation. In fact, I will not go through all the cases we have referred in our bundle of authorities, with regard to the element of premeditation, but just to indicate to the board that they are to be found at
So this passage then at page 288, line 17, is expressing the requirements of the law rather than summarizing the facts for the jury.
He was doing both, I would submit. That is, one of the requirements of premeditation is that the prosecution need to establish at some point in time the appellant was in a position where he could think calmly. That is the requirement. And I was referring the board to, I'm not going to go through all, but I mean, the relevant cases we mentioned on the issue of premeditation is to be found. That is the case of Leboeuf, page 394, the case of Radsuzamet, 682, the case of Viari, especially Viari, 695. And then we have cases from other jurisdictions, the US and the South Africa, but the three local cases we referred to, the three cases, Leboeuf, Radsuzamet, and Viari, where the board will see that one of the requirements, premeditation, that he must have thought about it and had some time, and this is where the issue is about whether it is a matter of minutes, whether it is a matter of seconds, and the case law seems to indicate that even if it is within a matter of seconds, someone can premeditate the act. At the end of the day, it is my humble submission, it's not really the timing which really matters. Of course, in a case where somebody had sufficient time to think about it for a week, it is more obvious that he had premeditated about it. But sometimes we have cases where accused parties, defendants, act on the spur of the moment. And the law says that even in these situations, if he had sufficient time to think about it, he was not under any type of pressure, that would be sufficient to prove premeditation. And we say that this is one of the cases on the facts where the appellant could have thought about it calmly. So what the learned judge was doing here, he was explaining the facts and the law. Now, when he says he seems to have acted calmly, he was in a way expressing partly his view. Now, sometimes a judge would be entitled to give the benefit of his analysis to the jury, but with the caveat, qualification, that it is for them to decide and that the jurors are not bound by what he has said.
I suppose the first question is whether there was an evidential basis for saying that he seemed to have acted calmly.
We say yes, my lord. We say yes because when one looks at the circumstances as we know it, that is, the statement, the way he described what he did, and especially before tying the shirt, the victim was powerless. It would seem that the three parties were in command of the situation. They were in command of the situation. They had even time to wash their hands. They were not in a hurry to leave the locus. Their appellant said that his two friends were washing their hands, which at that time. So we say, and the learned judge explained to the jury the circumstances in which it happened, the statement was before them, and it was for them to decide whether he acted calmly. So to that extent, we submit, therefore, that there was some evidential basis on which the jury could decide whether the appellant premeditated the act or not.
But just to be clear, the evidential basis is the fact that the other two washed their hands.
It is one of the
Well,
factors.
what are the others?
Well, Mr. Director, I wonder if there may be a simpler way of looking at the submission which I understand you to be making. If we go back to page 287 to see how this passage in the summing up begins, page 287 of the record, line 14, the judge says, let's look at the statement of the accused. We take what the accused has said for face value. Now these facts are going to come out from the statement of the accused. He then, in 9 numbered subparagraphs, summarizes the facts asserted in the statement. He then, at line 12 on page 288, says, still with reference to the statement, 2 Confederates were initially grappling violently, etc. The accused, for his part, was divorced from that heated action. His mind was involved with something else, placing banknotes in bags. So the judge here is still recounting what the appellant has said in his statement. And then, still dealing with the statement, as he finished that job, he approached the deceased, saw the state he was in, then seems to have acted calmly in removing his shirt and carrying out the act of tying the mouth of the deceased. So I think, if I've correctly understood your submission, you're suggesting that the judge in those 2 paragraphs is saying that on the face of the statement, the appellant himself says, my mind was elsewhere when I was filling the money bags, but it wasn't elsewhere when I was standing next to the deceased as he was shortly to become, and putting the shirt round him. And then at line 20, having completed that summary, the judge identifies the issue for the jury to resolve. Have I correctly followed the point you're making?
Yes.
Right.
Yes.
So the evidential basis is you submit, is looking at the contents of the appellant's own account and marking, if the jury think it appropriate to mark, a possible distinction between his state of mind when focused on filling the money bags and his state of mind when focused on doing something to the man on the ground.
Yes, he was very much involved, according to his admission, busy with collecting the money, and then he came, although that physically he was not very far away from what was happening. We said that there was no division, so he came, and he did the job. He did the job. He didn't hesitate 1 second, it would seem. He decided to tie the mouth with the shirt.
Could I just be clear about this, ask you to be clear about this? In answer to my lady's question, what are the matters on which you rely as an evidential basis for the judge's expression of view that he appears to have acted calmly?
It's as my lord just mentioned, that on the one hand he was very much involved with one thing at one point in time, and then he was asked, he was in a position to look at the circumstances, to make up his mind. A decision had to be taken, and there's no indication whatsoever that they were in a hurry, because in a situation like this, when you have almost killed somebody who was on the floor, there was blood on the floor, and you are in a bank, it would seem they could have left. They could have simply left after having tied his, after having inserted the papers and the sellotape. Now, to take the pain to tie the shirt, that would give an indication that there was some kind of liberty, they had time, they could do this. Otherwise, you would not expect them to tie the mouth of the shirt with the shirt, or to wash their hands. That is the reason why we say that the situation as described by the appellant in his statement would provide a basis on which the jury could infer, if they so wish, that he was acting calmly.
There's a point which may be only a small point, but it may be of greater significance here. The judge goes on to say in this sentence at 288, the accused then seems to have acted calmly in removing his shirt and carrying out the act of tying the mouth of the deceased, which act appears to have been uncalled for in the circumstances suggested earlier. And if we look back, I think that's a reference back to page 283, where the judge says, bear with me, it's passage beginning, so what was the need to tie his mouth again with a shirt?
Yes.
283.
283
at line 18. So what was the need to tie his mouth again with a shirt? If the purpose was to prevent the victim from shouting, then the adhesive tape was already performing that function. Now, once again, members of the jury, for your consideration, why did the accused tie the mouth of the victim with his shirt? I wonder whether it was necessarily established that the adhesive tape was performing that function. We're told that there was visible paper coming out of the mouth. I wonder whether that was a matter that should have been left to the jury, rather than the judge expressing a concluded view, as he seems to have done here.
There were the papers inside the mouth, and as well there was the tape. And the question that the judge was asking here was, if the mouth was already gagged with the sellotape, what would be the purpose of tying the shirt?
I understand that. The judge could have said to the jury, you may think, members of the jury, that if the adhesive tape was already preventing him opening his mouth, what was the point in tying a shirt?
This is what it seems.
He didn't do that. It seems to express a concluded view.
But he took the pain to say it is for you, members of the jury, to decide. Every time that he has expressed an opinion, that's why I say it's a balance. It's a summing up which is fair and balanced, in the sense that at some point in time where he expressed an opinion, he told the jury it will be for you to decide.
Yes.
And you should not. At the beginning of his speech, he said, whatever I have told you, whatever I've expressed as opinion, you should not feel like you're bound by what I have said. It is for you to decide on issues of facts. So to that extent, I submit that it cannot be argued that the summing up was not a balanced one, and it influenced the jury. It was unfair and prejudice to the jury. And also, we should not forget that on the issue about the gagging, the evidence, the medical evidence adduced was to the effect that the paper was deep inside the mouth. That is very important. And also that very part at page 714 of his statement of the record. Despite whatever the appellant seems to say, that despite all the observations he made about the victim, and these are the words which are very important, he said, even though, these two words are important, I say pregnant with meaning, because that would give an indication that he was in a position to observe the paper, the sellotape, the blood, everything. He said, even though I tie his mouth. This is something which the jury must have given sufficient consideration to what he said. So for these reasons, we say that there was a case before the jury, and the jury was entitled to decide, to conclude that there was sufficient evidence of intention to kill and premeditation.
Thank you.
Yeah. Thank you, my lord. Next issue I've been asked is with regard to the sentence. And
Before you move on to the sentence,
Yes.
there are various matters that I think members of the board will wish to raise with you.
yes.
I think my Lord Sir Tim Holroyd has some questions in relation to the presumption of intending the natural consequences of their actions in the law of Mauritius.
Yes, thank you. Mr. Director, you were addressing us yesterday about whether there was a presumption of law or an assumption or simply a basis, a strong basis for an inference. Could I ask, please, for your assistance with one of the cases which you mention in your written case and which we have in our hearing bundle at page 680. This is Mir Saheb, or Mir Saab, forgive me if I pronounce it wrongly. The Chief Justice and another Justice in the Supreme Court. Now, the facts of that case were that the accused had been convicted of an assault, the assault consisting in pointing a revolver at a woman and thereby causing her to fear for her safety and indeed for her life. Page 680.
Just while you're picking that up, I noticed in the transcript of the judgment of the no case to answer ruling, the judge relied on Mir Saab.
Yes. Yep. Thank you.
Yes,
So,
yes, my lord.
if you've got it, Mr. Director, the second paragraph of the report summarising the facts, the appellant then, for some reason, pointed the revolver at his friend's wife, who was sitting nearby. She got frightened. Husband pushed the appellant's hand away. The revolver accidentally went off, and somebody else entirely was unfortunately shot in the foot. Then, two paragraphs down, with regard to the conviction, counsel for the appellant argued the evidence did not disclose any criminal intent. The absence of any intention de nuire was confirmed by the fact that the appellant was visiting somebody who was his friend, and that what the appellant's act amounted to was no more than a playful gesture, never intended to cause any harm. So that's a denial on the part of the accused that whatever his actions may have looked like, he actually intended any harm. And then at the very foot of that page, the court says that the act of pointing the revolver at the wife was a positive physical act. It did cause the wife to be frightened for her very life and the husband to be worried enough to push the appellant's hand away. Clear, therefore, this is the top of the next page, that the material element of the offence existed beyond doubt. And then this passage, that material element also, it seems to us, gave a clear indication of the intention which the appellant obviously had. The pointing of the revolver in the direction of the wife was neither accidental nor involuntary. He intended, whatever may have been his motive, to point the revolver at the wife and must be presumed to have intended the natural consequences of his act. The consequences being a physiological impact, fear for her physical integrity, on the wife. And on that basis, the challenge to the conviction on that charge was rejected. Now, I just wondered, your submissions to us yesterday were that really there's no presumption of law. It's just that the facts may justify the inference. And clearly here, in the circumstances of this case, the facts may justify the inference. But the Supreme Court doesn't there say, on those facts the jury could find. It says he must be taken to have intended the consequences, even though he denies them. So I'm afraid, speaking for myself, I'm not entirely clear what the submission is as to the status of that doctrine under the law of Mauritius.
Yes, I think the case of Mir Sahib should be considered in its proper context, because in this case the charge was one with assault, and the Supreme Court referred to the presumption to the presumption, but it must be presumed that he must have intended the natural consequences of his act. He was pointing the revolver towards the wife, and the pointing of the revolver towards the wife, that would amount to an assault. The mere pointing of the revolver towards the wife would amount to an assault. That is an apprehension of harm being caused without the actual assault taking place.
But
psychological.
Sorry, say again?
Psychological consequences that could follow.
But surely there's a mental element to the crime.
Yes.
What if they were posing for a photograph, for a fashion shoot?
On the facts of this case, cannot be, my lord.
No, but your proposition that you've just advanced to us goes way beyond the facts of that case. You're saying the mere fact of pointing the gun at someone is a crime. And as I read the Supreme Court's judgment, there has to be an intention de nuire.
Yes, yes.
The accused denied any such intention, but the Supreme Court held that he must be presumed to have held it. Not that the jury might find he did, but that he must be presumed to have held it.
By holding the gun towards the defendant, pointing to the defendant, what the Supreme Court was saying, that by his act, he may deny it. He may deny that this was not his intention. It was not to cause harm. But the mere fact that he pointed the gun must be taken to mean that he must have intended to cause harm. Otherwise, why pointing the gun towards the wife? That is the reasoning of the Supreme Court, the way I understand that passage here. Why would you point the gun towards the wife if it was not to frighten him? So that is in the same way the learned judge in the extract that we looked at yesterday, he seemed to be saying, he seemed to be explaining the state of mind. That is, it is too easy for a defendant to do something and to say, I didn't intend to do it. But there are certain facts and circumstances which would point only in one direction. And this is where the inference becomes important, where the circumstantial evidence becomes important.
So you're saying in Mayor Serra, it was an inevitable inference on those facts?
Yes, my Lord Hamblin is right. That is, the only reasonable, irresistible inference that one would draw from that was to cause harm.
So just to be clear, if we read what the judge said in his summing up to this jury as in effect directing the jury that there was a presumption of law, that would be a misdirection. You say we shouldn't read it like that, but if we did read it like that, that would be a misdirection of law.
Yes.
I see. Thank you.
I'm sorry for bothering you, but are there any cases of which you are aware that make that absolutely clear, that this is an inference of fact rather than an inference, a presumption of law? We have this one case which you helpfully referred to and put into our bundles. And,
the thing is, my Lord Stephens is right to ask that question. Yes. The difficulty here is that our law, our criminal law, as I said yesterday, is based on French law. Yes. Now, the French, they don't have, as we have it in Anglo-Saxon jurisdictions, rules of evidence, yes, strictly speaking. Yes. So, for example, Anglo-Saxon, we have presumptions, which is a rule of evidence. Yes. They don't have it. So they would rely mostly on facts, circumstantial evidence, inference which can be drawn. That's the distinction. If we look at presumptions in the context of English law, the French position is quite different, and we should not confuse both to mean the same thing. We're talking about two different things here.
But in any event, it's clear that these are presumptions of fact. They're inferences of fact.
Yes. So I move on now to the issue of sentence and the delay.
There are one or two other matters that I do need to canvass with you, Mr. Director. I should not be taken to be giving, in posing this question, I should not be taken to give any indication as to my thinking or the thinking of the board, but we need to address various possibilities. If it were the case that the board were to conclude that on one or other or more than one ground the conviction was unsafe, what powers would be open to the court? What possible courses of action might be open to the board in relation to the future conduct of these proceedings?
If the board were to come to the conclusion that the conviction is unsafe, we are not referring to application of the proviso here.
Well, the proviso is another matter on which I want to hear you in a moment.
Yes.
But if we were to conclude that the conviction was unsafe and that there was no scope for the application of the proviso, is it simply a case of our quashing the conviction?
The other possibility, the possibilities are that the application of the proviso, that's one thing. The substitution of the sentence, not of the sentence, but the conviction for a different charge, substituting.
So one course would be, we're assuming now that the proviso does not apply.
Yes.
So one course would be that we could quash the conviction.
On murder.
For murder.
And substitute for another offense.
Well, and then another course would be that we could quash the conviction and substitute a conviction on a different charge.
Yes.
However, if we look at the judge's summing up to the jury, he identified 5 different tiers of offences of diminishing seriousness in respect of which this accused could have been convicted.
Yes.
How are we to distinguish between those alternative offences?
Well, as I explained yesterday, that is, the most serious one is murder. And we've discussed yesterday about the different elements of the murder. If, for example, the board were to find that all the elements were established, except, for example, premeditation, that would be a charge of manslaughter. If, for example, the board would come to the conclusion...
Well, stopping there, premeditation would be necessary for a conviction of manslaughter, would it?
No, murder.
Just intent.
Just intent, right.
If, for example, the board is not with us on the issue of premeditation, that is, the defendant didn't have sufficient time to think calmly, one possibility would be to substitute murder for manslaughter if the board is happy that all the other elements of the offence were present. That would be.
I'm sorry, I was reading the wrong direction. It's at pages 289 to 290 where they're set out, and I was reading the second alternative, which would have resulted in a conviction of assault causing death with premeditation, but without intention to kill.
Yes. Yeah. So these would be the different possibilities.
But these possibilities turn on conclusions as to matters of fact.
Yes.
Which we may not be in a position to do.
So then the only option would be to order for a new trial. Because these would be matters of facts which a jury or court of law would have to decide.
Should the question whether there should be a retrial be a matter for the board, or should that be remitted in those circumstances for consideration by the Supreme Court?
I think the Supreme Court would be in a position, unless you, my lady and my lord, you're in a position on the facts, on the evidence which were elicited and before you, you are in a position to decide whether what would be the appropriate charge, whether it should be remitted for a new trial.
Yes.
Yeah.
Thank you. And finally, Is there anything further you want to say in relation to the proviso?
Yes. So insofar the proviso is concerned, our submission is that when one look at we say that on the facts of the case, altogether, that is, the prosecution had a strong case to be presented before the jury. Yesterday we look at the admission, that is the real evidence and everything, and we say that there was a strong evidence, there was a strong case to be presented before the jury, the admission of the real evidence as well. And when we look at the case for the defendant, we say that there are many issues which have been raised here which were not really challenged before the trial court and therefore cannot really be successfully argued before this board. Be it in terms of the issue of causation, in terms of challenging the weight of the statement, and so on and so forth. In fact, very briefly, whether the deceased was already dead, the doctor was never cross-examined on this issue. The causal link between the shirt and the death, there was no cross-examination. About the written deposition challenging the weight was never challenged. As far as no evidence of mens rea and premeditation, we say that on the evidence, for the reasons we've given, that there was evidence on which the jury could find intention to kill and premeditation. Now, except with regard to the mistake of the nose. The mistake of the nose, we say that it is a misdirection, yes, but for the reasons that we gave yesterday, it is not of such a nature to amount to a miscarriage of justice. But if the board were to conclude that it amounts to a miscarriage of justice, then we argue that it's not a substantial one. Therefore, the board would be entitled to apply the proviso. And we referred the board to a number of cases where the proviso with similar statutory provisions like in other jurisdictions where the board did apply the proviso. And these cases are to be found at series of cases, that is the case of DPP and Stonehouse.
Yes.
The case of Cohen and Bateman, the case of Lily Perry.
Sorry, the second one is?
DPP and Stonehouse. Then the case of R and Cohen and Bateman. I mean, this case is a 1909 case, but more recent cases, we have the case of Hamilton and Lewis and the Queen, decided in 2012. The case of Brown and the State, 2012, Livingstone, 2012, and the recent case of Miller and the King, decided in 2023, UKPC 10.
Yes. Now, in formulating that submission,
Yes.
you excluded the mistake in respect of the nose.
Sorry,
I understood you to exclude from that submission the mistake in the case of the nose, covering the nose. I thought you.
I think he was addressing that.
I see. You were expressly addressing that situation. Thank you for that clarification.
Thank you, my lord. Yes, this is with regard to the application of the proviso.
Can I just bring you back? I'm sorry.
No, not at all, my lord.
The options, and again, I ask these questions without any assumption being made about what my views are. But if one of the options is for the board to quash the conviction, if we do so and then remit to the Supreme Court the decision as to retrial, does the Supreme Court have jurisdiction to substitute an alternative conviction?
No, I mean, if the board were to order for a new trial,
yes,
there will necessarily be a.
Well, sorry, I understood you to prefer that rather than the board deciding whether there should be a retrial, the matter should be that question should be remitted to the Supreme Court.
I say that if there is sufficient material on which the board can decide that question, I would submit that the board itself
Decides on a retrial.
on the retrial. And then once the board decides for a new trial, there will be a new trial.
Okay.
Yeah.
And so, in such circumstances, you would be applying for a retrial, and as I understand.
Yeah.
And you would be doing that in preference to asking the board to substitute a conviction? I mean, for instance, it might be said that the second lesser offence, that is, the accused parties acted with premeditation, that is, all of them. It might be suggested that there was a plan between the three people to attack the person in the vault, to commit an assault on that person, and that was the joint intention of all of them. How the assault was to be committed, of course, was another matter. In the event, as things turn out, it was committed by stuffing his mouth right up to his larynx with paper and covering his mouth with sellotape. And in the event, that alone would have killed the victim. So it might be said that there was an extremely strong case, shall we say, in relation to the second lesser offence. Mm-hmm. But your preference is to apply for a retrial. Is that right?
My preference, my lord?
Would be to apply for a retrial.
Yes, in this scenario, yes, a new trial. Yeah. Thank you.
I'm so sorry to add yet more questions on this,
not at all, my
Mr.
lord.
Director. Yeah. And again, the questions are on the basis of considering the various possibilities, not indicating any views. But I just wonder whether we need to be absolutely clear about what you mean by a retrial. The appellant at various times was charged with murder and manslaughter. In the end, he was tried on the charge of murder. As I understand it, he has never in fact been charged with any of the various lesser offences which the judge canvassed. So if the murder conviction was quashed, unless the law of Mauritius is very different from the law of England and Wales, it would be open to the prosecution to charge him for the first time with one of the lesser offences. But certainly in this jurisdiction, if an appellate court simply quashed the existing conviction full stop, there is then nothing to retry. In this jurisdiction, the court must at the same time order the retrial as quashing. Otherwise, it is too late to come back and say, well, can we have a retrial on the same charge? That charge no longer exists. And in this jurisdiction, the accused would be entitled to plead autrefois acquit if charged. So can I just be entirely clear? If the board concluded that the conviction should be quashed and that the proviso didn't apply, would you be wishing to retry on the charge of murder or on a charge of murder or manslaughter which have been charged before, or would you be looking to charge afresh with a lesser offence which hasn't previously been charged?
First thing, what my lord says, that is, the appellant was never charged with other offences before he was charged and convicted. There was only one charge, murder, before the Supreme Court. The other charges of manslaughter or murder was possibly at the stage of preliminary inquiry, committal proceedings. Yep. But the main charge was one of murder.
Understood.
Now, to answer the question of my lord, of course, the prosecution will have a look, will have a fresh look at the case, at the evidence, and decide on the appropriate charge. But what my lord said, that is, to order a retrial, it is important for the board to find that there was an irregularity, a serious irregularity.
All these questions are based on that.
Yes. So when the board find that if the board were to find that there was a serious irregularity and therefore order a fresh trial, of course it will be for the prosecution to decide, and we will bear in mind all the relevant factors what we've discussed to decide on an appropriate charge. But at this stage, I cannot say what would be the exact charge for which the appellant would be prosecuted if ever there's an order for a new trial.
Right, thank you.
Yes.
It's always intrigued me as to why he wasn't prosecuted also in the alternative for robbery.
Yes, this is a very good question. I thought about it even when I was looking at the case. Very good question. I was expecting that question. In fact, there is a practice in Mauritius, like when you go for the most serious offences, you simply don't proceed with the lesser one. But I think this is a practice which we need to review seriously. Yes.
The case that was being made in relation to murder was based on two scenarios. Yeah. The first one is that they all jointly intended, in certain circumstances, to kill anyone who resisted. And so at present, the concentration has been on the second scenario, namely him as a principal, because potentially the judge didn't advert correctly to intention to kill in relation to joint enterprise. So I can see that there are decisions to be made by the prosecuting service as to exactly what charges to bring on a retrial. And I suppose we'd like to know sooner.
Yes. If we were to find ourselves in that position, and all this is put on a contingent basis, if we were to take a particular view, if we were to find ourselves in that position, the board would need to know with which offence or offences the accused would then be charged.
At this stage, my lord.
Not today, but before the board concludes its deliberations.
Okay, so the board would wish to know that if a fresh trial is ordered, what would be the appropriate charge to be lodged against the appellant?
What is your submission as to the appropriate charge?
Yeah, I would think unhesitatingly something which is lesser than murder.
You're saying it would be something less than murder?
Less than murder, certainly not murder.
But I think we would need to know precisely which offence would be.
It could be.
But I'm not asking you to answer that now, but I'm just indicating that we would need to know at some point before we conclude our deliberations as to what you say would be the appropriate charge.
And we're not suggesting in any way what we consider to be the appropriate charges at all. I mean, it's entirely a matter for the discretion of the prosecutor.
I think one possibility would be manslaughter.
But again, it's a matter for
it's a matter for you.
Sorry, I can't. Existing retrial. Are extraordinarily limited.
Do you know what sentence those who pleaded to manslaughter received?
Usually, it's a range between 35 to 40 years.
For manslaughter?
Yeah, for manslaughter, yeah. Depending on the circumstances of the case. That's the normal range.
So normal range for manslaughter is what's
It's 32 to 40 years.
Yes.
Now then, Mr. Doherty, you were going to take us to sentence.
Yes, my lord. As far as sentence is concerned, very briefly, I think the Court of Criminal Appeal agreed that the appellant was entitled to a reduction in sentence in view of the delay which was caused from the time he was arrested until he was convicted and the case was heard before the appellate court. In fact, at page 351, this is the record. This is what the learned judge, when imposing sentence, took into account at page 351 of the record, all relevant considerations. And it would seem, he said, that the convictions accused are indicative of a pattern of conduct showing repetitive offending. In fact, the appellant, while he was on bail after having committed this offense, he committed another offense where he attacked somebody and he stole money. That is on record. Page 351 of the record, that is line 12 or 13. And also, if your lordship and your lordship will see at page 435 of the record, his record of conviction, your lordship and lordship will see that in 2011, after the commission of the present offense, the accused, in company of confederates, attacked declarant and stole a sum of 1.8 million. He was charged with conspiracy and knowingly receiving property obtained lawfully. So that's why the learned judge said that he's a man of a pattern of conduct of showing repetitive offending. He seems to have a propensity to reoffend, and I submit that the sentence initially imposed was justified in the circumstances, and the appellate court reduced that sentence by 2 years, and we look at the established principle of this board. 2 cases we have indicated in our written case at paragraph 186. We refer to the case of Raman, which was decided by the board. Raman is to be found at electronic bundle reference 554, as well as the case of Celine, which is another judgment of the board, and this one is to be found at page 563 of the electronic bundle. Case of Raman and the case of Celine. So the principle established by the board when it comes to a delay, it would depend on many factors when it comes to reduction in sentence, and there's no hard and fast rule. Especially a case which is of serious nature like the present one. In the case of Raman, it was said that a breach of that right will always be a factor to be considered in deciding upon the appropriate disposal.
Sorry, where are you reading from?
I'm reading from the case of Raman.
Yes, which paragraph?
Yes.
Or page?
I'm reading at paragraph 13 of the judgment.
Thank you.
Where the board said a breach of that right will always be a factor to be considered in deciding upon the appropriate disposal. In some instances, it may not be a factor of great weight, and there may even be some cases in which, because of the strength of countervailing factors, such as gravity of the offense, it will be accorded no weight at all. But it will always be a factor to be considered. So in the present case, we submit that it was one of the most serious offenses, which is murder, and therefore a reduction of 2 years by the Court of Criminal Appeal was justified in the circumstances. Now, why I refer to the case of Céline? The case of Céline was a case where the offense was one of forgery, making use of forged document. In that case, the defendant was sentenced with 3 years imprisonment. There was a delay of 17 years, 1-7, and an appeal. The sentence was reduced by about 2 years and 3 months only. So we submit, therefore, that the 2 years reduction in sentence was justified.
Can you help us about what caused the delay?
Yes.
There are many reasons, my lady. It's because first the prosecution proceeded by way of committal proceedings. That took some time. To start with, after he was arrested and the investigation started, the police took 4 years to dispose of the investigation. We have chronology. Let me, if I may, refer to the chronology which we have provided very briefly. Page 24. The electronic bundle.
The key bundle, yes.
Yeah. Yes.
So what happened between October 07 and April 09?
Yes, there's another chronology. I apologize for that. The one I'm referring now is at page electronic bundle 1780, which is more simpler version. 454 of the record, or electronic bundle 1780. So the board will see that the offense was committed on February 2005, and that there was first committal proceeding on 2009. So between 2005 and 2009, that was in police investigation. After it took about a year for the committal proceeding to be disposed, where all 3 parties were committed to stand trial before the assizes on the charge of murder, 2010.
I suppose one of the questions is, did the appellant contribute to any of this delay?
It's a very tedious exercise, but we need to look at, for example, during the preceding committal, whether there were unjustified points being raised and so on and so forth. But I think there was a general agreement that there was delay, and that the Court of Criminal Appeal took the view that 2 years in the circumstances would be justified.
Do you know, Mr. Director, whether any reduction in sentence was made for the 2 who pleaded guilty to manslaughter?
I don't think so.
Their proceedings ended in 2013.
When they pleaded guilty, what I can tell the board that they were sentenced to 16 years.
Both of each 16.
Yeah. I cannot say it must be that
Sorry, each 16, yes.
16, yeah.
And that would have accounted for credit for guilty pleas.
Yes, yes.
And is that 1/3 credit or, I'm sorry.
No, no.
It's too much detail.
No,
Ordinarily.
usually, yeah.
Yeah, okay.
Yes, 16, yeah. Possibly, I don't have the sentence, the judgment, the sentence, but the delay was, could be that delay was taken into account. But it will appear that the delay was taken into account as well to answer the question of my lord. So this is the chronology that is took some time and we must say that there were different motions made. For example, we can say in the chronology in 2012 when the case was called before the Supreme Court, a motion was made on the ground of abuse of process. A judgment was delivered subsequently. Then there was the guilty plea, there was a discontinuance of proceeding, another information indictment was lodged. I can see other motions on the part of the defense. On the 5th of February 2014, defense motion for translation of brief, ruling on the motion, and so on and so forth. So a trial started, full trial started in 2015. That would explain the reason why it took so much time, it would appear, for a verdict of the jury, my lady.
Do you know, Mr. Director, what reduction was made in the sentences of the other two on grounds of delay?
It doesn't seem that the judge who presided over the hearing gave the reasons, the specific reasons for the factors that he took into account.
Okay, thank you.
He only said, if I may, in the light of the foregoing observation, that is the judgment of the board in general regarding the reduction in sentence when it comes to delay, in the light of the foregoing observations, after taking into consideration the seriousness of the offence, circumstances in which it was committed, I hold that the accused deserve a substantial custodial sentence, consequently taking into account the credit they are entitled for pleading guilty, mitigating factors invoke, I sentence both to 16 years penal servitude.
Okay, thank you.
Unless, if your lordship would wish to have a copy of the judgment, we can favour, if any.
Yes, that would be very helpful. Thank you. Thank you.
Anything on which I might be able to assist my lady and my lord?
One very small factual matter, if you can help. Did the jury have copies of the statements made by the appellant?
They did not.
No. So they were read aloud during the proceedings, but the jury...
It is as and when the trial proceeds, then the documents are put in, and then they are able to have a look at the document.
But do the jury take those statements with them when they retire to consider their verdict?
Yes.
They do, right.
Yes, they are provided with copies of all documents.
Thank you very much.
Thank you. Anything further?
Thank you.
Thank you very much, Mr.
Thank you,
Director.
my lord.
Mr. Ramdo.
May it please you, my lords, having exhaustively listened to what's been said and question asked, I personally feel that the board is much more equipped than I can imagine. I do not intend to so much. Just have to forgive me, it's not my usual because of my health, but I'm trying my best. The only thing, my lord, I just want, although we're past the stage, is just to give you a hint about the intention, which I was averse to it, but I just could not bring it for you. Just to think about, if you were to look at the e-bundle, page 2057.
Sorry, which?
2057.
Bear with us, please. Page?
2057.
So this is the second witness statement of the appellant.
Correct, my lady. I would draw your attention at line 10.
I'm sorry, I have a problem. Yes, line 10.
Yes, line 10. I'm just drawing your attention on what he said, the appellant. Line 10, it starts a little after their departure. 3 p.m. news was given in the radio. I do not understand which station. And we heard that a person had died in the vault of MCB Port Louis. And then further down he goes, just line 18. Then we understood that the case had become serious and news has been spread. I'm submitting this, my lords, just simply that here is a person, as I said very strongly in this, the intent.
Very strongly.
Sorry, my lord.
We didn't hear the.
Sorry, let me see if I can repeat that.
Yes, please.
In this, I was trying to explain that the intention of the appellant, and these 2 lines gives us an indication that if there was an intention to kill or to have this kind of injury, the appellant would not have been surprised on the radio's news. And
if you take it at face value, what he says is correct.
yeah, so it just what we are saying here, that this was said, so a person who had intended to kill would have not said any of those. That's my whole idea, that a person who intended to kill or knew he was killed or he was badly injured, he would not have brought that. I mean, that's all a point I'm trying to make. When we're talking about intention, I'm just digging into, I looked at it. This is my personal view I've taken with the help of those who are discussing this matter.
He could have had an intention to kill.
Sorry, Myro?
He could potentially have had an intention to kill, premeditated intention, by the planning process. The chances of obtaining wealth beyond his wildest dreams could have put at peril the life of the people in that vault.
Well, my lord, I'm not going to argue this. He could have thought of many things. That I'm not taking an issue with. I'm simply saying these 2 lines to me gives me an indication that if somebody had planned, or these words wouldn't have even occurred, would not have come out. This is my view. But my lords and lady, you are to decide how you take it. I just gave my view on this. Having said that, my lords and lady, I can only say this, that the main issue came to me about this. The appellants said, would you please? The appellant's view was given to us simply that he is guilty of all the wrongdoing regarding the robbery. But he never intended at all, at any cost, at any time, to injure a person or to cause death. And that is what he is fighting. In that respect, we tried our best. My colleague here has been in the case all the time through and done his best. I have also the solicitor behind me sitting, Ms. Sarkar, Sapana Sarkar, has helped me a lot to go through seeking and looking for the intention, if there was any premeditation, and how the act happened, whether it would have led to a kind of situation where one could say is a murder. So that's all I can say, my lord. I just have put my point, I've explained. I am very sorry I have not been as good as I should be, but it's just a result of my situation at the moment, a kind of health. For that, I ask for you to forgive me. And I do not have anything else to say unless you have any question to ask which I can help.
Thank you, Mr. Rambo. We're grateful.
Thank you. Thank you, Mike. Thank you, my lady.
Well, Mr. Ramdoon, Mr. Director, we are grateful to you both for your submissions. We're also grateful to those sitting alongside you and behind you for the preparation of the case and the assistance that they've been able to give. This is a case in which the board will take time to consider its judgment, and you will be notified in due course. I'm reminded by my lord, Mr. Ramdoon, there is one matter that we should raise with you. And that is, what do you say is the appropriate course if your appeal is successful? What do you say is the appropriate course for the board to take?
Sorry, my lord.
If your appeal is successful, what is the appropriate course for the board to take?
Well, my lord, there was a question of cost, of course.
No. In terms of quashing orders, directing a retrial, substituting a conviction.
Well, my lord, a retrial is not something conducive in any way because of the time situation. That is not at all an approach which I would suggest or I would approve. But the next thing is the action that the board or the court in Mauritius should consider is what is the sentence in relation to the robbery and the worst punishment that is due under that act they've committed. So that would be my view in this matter.
So you're asking the board to substitute a sentence of robbery?
Yes.
A conviction for robbery?
Yes, my lord.
Is that a course which is open to us on this indictment?
My lords, at least if the board is not open to this, can obviously suggest to the country, the state concerned, to see that that should be done, because that's the only thing they could do, is to give the man the sentence due under the robbery.
But the jury's findings don't support a conviction for...
Yes, but that is a matter for them, my lady. I cannot say how much and what can be done.
Very well. I don't think we can be able to take it.
Do we want to do a timetable to come back on lesser charges?
Different charges.
Or different charges?
New charges.
For a retrial? I don't know.
Yes. Mr. Director, it would assist us if you could, within 28 days, notify us of what you consider would be the appropriate charges to be preferred in the event that the conviction
Yes,
was.
I will, my lord. I will. Thank you.
Thank you very much.
Thank you very much.
I renew my thanks to all concerned in the preparation and the presentation of this appeal. The board will take time to consider its judgment. Thank you.